Welcome to today's webinar, brought to you by the Current Consulting Group and sponsored by DrugPack. Today's presentation is titled Prioritizing Drug Testing to Optimize Legal Defensibility. Today's webinar qualifies for one continuing education credit from SHRM, HRCI, and CCDAP for those who attend in its entirety. You will receive information following today's webinar on how to apply for that credit. We're excited to hear from today's webinar sponsor, DrugPack. So let's go ahead and turn it over to David Gonsalves, General Manager at DrugPack.
Good afternoon. I'm David Gonsalves, General Manager of DrugPack. We're happy to sponsor this presentation focusing on prioritizing drug testing to optimize legal defensibility. Before I turn the time over to Yvette Farnsworth-Baker, Senior Legal Counsel for the Current Consulting Group, I want to say thank you to the drug testing industry. In the upcoming months, DrugPack will be entering its 36th year in business. Today, as well as throughout our history, we're grateful for our customers, partners, and vendors that help make our software better each year. Our solutions are ever evolving to meet the needs of individual companies and the industry as a whole. As we enter the year-end holiday season, I would love for you to take a look at my software, DrugPack. If you haven't looked at it lately, or if you're an existing user but haven't fully investigated all of the advanced features we offer, please contact us at sales@drugpack.com. We would be happy to walk you through all the features of today's DrugPack. Now, let's take a look at a short video about DrugPack and some of its customers. Today's presentation is important and timely. Oral fluid is on the horizon for the Department of Transportation. In addition to that major initiative, there are changes in your respective states, communities, and businesses that are or will require drug and alcohol policies to be evaluated and updated. It's important for all of us in the industry to keep up to date on what is happening from a legislative and cultural perspective. We at DrugPack wish you the best as you seek and identify solutions that will help your business and employees succeed. And now it's time to hear from Current Consulting on prioritizing drug testing to optimize legal defensibility.
Well, thank you so much, David, for that introduction, and thank you, DrugPack, for having me here today. My name's Yvette Farnsworth-Baker. I'm an attorney with the Current Consulting Group. I'm Current Consulting Group Senior Legal Consultant. I am a licensed attorney in the state of Florida, and I practice law, and I'm also an expert in drug and alcohol testing, case law, state law, compliance, all those sorts of things. So I speak a lot at webinars and events like this. I write and just try to lend my legal expertise to the area of drug testing law. So let's get started talking about legal defensibility and drug testing laws. This is a brief agenda. We're going to talk about state laws, updates on state laws and federal laws. We're going to talk about what legal defensibility really is. We're going to talk about what kind of state laws there are out there to understand what applies to the workplace. We're going to talk about different drug testing methods and how that applies to legal defensibility. the 3 C's of legal defensibility, and we're going to close up speaking about marijuana in particular. We're going to be talking a lot about marijuana throughout the webinar, of course, but we'll end specifically talking about legal defensibility and what to do with marijuana. So let's just start out talking a little bit about the fact that drug testing in the workplace can be very complicated. I mean, at the Current Consulting Group, this is what we specialize in, and the reason we can have an entire consulting company specializing in this subject is because it's very complex. The science, the legality, there are so many steps in the process where an employer can go wrong. Not saying that to scare anyone away from it, but just to make sure that employers and the industry are understanding that there are not quick answers. They're not quick and easy answers for employers. Drug testing. These are things that really need to be thought through carefully and with an education to the laws that apply, all the way from step 1 when you're writing a policy or putting a policy together, through carrying that policy out, collections, testing, what to do with results, all of that. There can be pitfalls along the way for those who don't know what they're doing. So I'm here to help. I'm here to identify the issues. And of course, at Current Consulting Group and at Drug Pack, we always have people at the ready to help anyone who has more questions. So I talked a little bit about how you can go wrong or how there are pitfalls when you're drug testing, but I also do really want to point out that there is a huge pitfall for employers who choose not to test. What I have up here on the screen right now are 2 legal doctrines. One is negligent hiring, also called negligent retention, and the other is respondeat superior. And really all you need to know about these 2 legal doctrines are these are legal doctrines in which an employer is legally liable for the actions of his or her employees, particularly his or her dangerous employees. And that's what we call in the legal field employees who cause harm. They are liable to other employees in the workplace. The employer is liable to other employees in the workplace when they have individuals employed who are a danger. They are liable to the public, to their clients. And we are not just talking about physical harm, but also harm to the company. Well, really what I'm thinking of is breach of data, breach of privacy, client information. All kinds of things can go wrong when you have an employee who is impaired in the workplace and making dangerous decisions. Of course, physical safety is the biggest one and the most important one, but there are other things that can go wrong with impaired employees that can make an employer legally liable. So we have to keep that in mind when we're talking about drug testing. So at the Current Consulting Group, we do a survey every year. We survey employers and we survey the industry to get just the temperature of what people are thinking and feeling and doing, what actions they're taking. So this is some results from our 2023 survey. And we asked, why maintain a drug testing program? And of course, the biggest reason that we got was to promote a safe workplace, and that's absolutely how it should be. And the next 4 reasons are all relevant as well to what we're talking about here today. Complying with legal requirements, either the Department of Transportation, state laws, other federal requirements, or minimizing legal risks. Now, all of these top 5 reasons to drug test all have to do with legal defensibility and the liability that employers can face through their employees. So a safe workplace, legal risks, complying with laws, these are all really important when we're talking about a legally defensible drug testing policy. Now, we also asked this year and every year, what benefits do companies realize from drug testing? And again, the number 1 reason almost every employer says improved safety in the workplace, which is so important. And number 2 is hiring quality employees, which when we're talking about the liability employers have based on the actions of their employees having a safe workplace and high quality employees is hugely important. So we're going to get talking about laws, mostly state laws that have changed in 2023, or the state of laws in 2023 that impact workplace drug testing. So trends that we've been seeing this year, the number one trend we've been seeing is employee protections in marijuana laws. These are either portions of a marijuana law written right into the marijuana law or standalone laws that give employees who use marijuana, who use legal marijuana, protections in the workplace, protections from discipline, protections from discharge, protections from not being hired. So that is a huge trend, and we're going to continue to see that in 2024. We do see some employer protections in marijuana laws, laws that are passed that say an employer does not have to accommodate marijuana use. Those are less common than employee protections, but they are out there. We continue to see marijuana legalization. Medical marijuana legalized in states that have not legalized it yet. Recreational marijuana legalized broadly. We additionally see with medical marijuana an expansion of qualifying conditions. So when medical marijuana laws were new, there were usually very specific conditions that could be prescribed, or not prescribed is not the right word, but recommended, I believe is the word they use with medical marijuana. You can get a medical marijuana recommendation. It's not technically a prescription, but you had to have very specific conditions, medical conditions, in order to receive a medical marijuana recommendation. That is expanding now. Those qualifying conditions are expanding, and as well, a lot of states are just removing them altogether and saying that a person who needs marijuana medically does not need to show any particular condition in order to receive a recommendation for medical marijuana. With recreational marijuana, we also see a lot of states that already have legal medical marijuana expanding into recreational marijuana. So some state laws that passed this year, we actually just had one pass recently after we put this slide deck together. Ohio passed a recreational marijuana law as well. That's not on here, but do take a look at that. Take a look at that as well. It passed in a voter initiative in the most recent election. Minnesota and Delaware both legalized recreational cannabis. The state of Kentucky legalized medical cannabis, and the state of Washington passed a law, we're going to be talking about this quite a bit, that restricts pre-employment marijuana testing. Washington has had legal marijuana for a while, but now they are offering more protections to applicants in marijuana testing. So first I'm going to talk about this law in Washington. So in Washington, this law is taking effect, I believe, January 1st, 2024. So coming up, an employer cannot discriminate in hiring. Now, this is only in hiring. This is not for current employees, but in hiring, an employer cannot choose not to hire a candidate based on off-duty cannabis use, or based on a drug test result indicating the presence of non-psychoactive cannabis metabolites. Now that is a mouthful and that is a little bit confusing. We're going to talk about it a little bit more later, but what that means is employers can drug test, but if they want to choose not to hire someone based on a positive marijuana test, they have to be testing using a drug testing method that indicates the parent drug of marijuana and not non-psychoactive cannabis metabolites. It's not to say that employers are not allowed to drug test in Washington. They are allowed to drug test in Washington. They are allowed to do pre-employment drug testing, but they have to select their drug testing method with an eye to this law. Urine testing detects non-psychoactive cannabis metabolites, as does hair testing. So urine testing and hair testing are not going to be ideal for pre-employment testing in Washington because an employer cannot refuse to hire someone based on a urine test or a hair test that indicates marijuana. Oral fluid testing and potentially breath testing are not detecting non-psychoactive cannabis metabolites. So oral fluid testing and potentially breath testing could be used to refuse to hire someone. A positive oral fluid test for marijuana does not fall into the restrictions of the Washington law. We're going to talk about it more a little bit later, in addition to California that has a very similar law, because I know it's confusing. I've done whole webinars just on this subject. But I'm going to move on right now to Minnesota, who legalized recreational cannabis. In Minnesota, employers cannot discriminate against medical marijuana users based on a positive test for cannabis, and that's for medical users. Employers cannot refuse to hire someone based on off-duty conduct, and they cannot request someone undergo a marijuana test based on an arbitrary or capricious basis. This is all very complicated, but what it means is off-duty legal marijuana use cannot be the reason to refuse to hire someone. An employer cannot ask employees to take a marijuana test without cause. Random testing for marijuana or, broad pre-employment testing, in my opinion, falls under the umbrella of arbitrary or capricious basis for testing. Reasonable suspicion testing or post-accident testing if there is an indication of impairment causing the accident, those would be permitted. So you need to look, if you're operating in Minnesota, you need to look closely at that law and closely at your drug testing policy to see if you're in compliance. Delaware, like I said before, legalized recreational cannabis, but their law does not impact workplace drug testing. The law does not restrict drug testing, does not restrict action that an employer can take on a positive result. So drug testing for marijuana in Delaware can operate as it always has. Kentucky legalized medical cannabis, and like Delaware, it says employers can still restrict medical cannabis use by employees, can still test for marijuana. However, patients are not considered under the influence solely based on cannabis metabolites. But employers are not restricted in the actions that they can take. So, like I said with Washington, beginning in 2024, urine testing for pre-employment is going to restrict what employers can do with a marijuana positive. California has a similar law that was passed in 2022, but it is taking effect January 2024. The California law is not just pre-employment testing. It's all workplace drug testing for marijuana in California. In California, like Washington, an employer will not be able to take adverse employment action, meaning disciplinary action, refusal to hire, discharging an employee based on a positive marijuana result if the drug test indicates non-psychoactive metabolites of cannabis. Again, a urine test and a hair test are testing for non-psychoactive cannabis metabolites. An oral fluid test and possibly a breath test are detecting the parent drug. So oral fluid testing, breath testing are not restricted the way that urine testing and hair testing are in both California and Washington. So considering a drug testing policy, what is going to be most legally defensible across the board, an employer really, really wants to consider oral fluid testing because it's detecting the parent drug. It's going to be one of the only drug testing methods that are going to give them a leg to stand on to discipline employees in the state of California, and also Washington's pre-employment testing beginning in January 2024. So again, like I was saying in the intro, An employer needs to think about their drug testing policy all the way from beginning to end. Employers need to take a look at their written policies and what samples they are testing. Are they testing oral fluid? Are they testing urine? Are they testing hair? And consider which is the ideal sample type for their workplace. All right, so we're going to talk a little bit more about what legal defensibility really is. When I say legal defensibility, what am I talking about? I am talking about reducing your legal risk, reducing your exposure to lawsuits. I'm a practicing attorney. I can never tell someone, if you do this, you will not be sued. People get sued for everything, right? We know that in the US, unfortunately, you can be sued for anything. And there's no way to handle drug use in the workplace or workplace drug testing in a way that you're never going to face any exposure to lawsuits. What you can do, though, is what an employer can do is put himself or herself in a position where if you had to defend your policy in court, you are on the strongest footing. Okay, you are complying with laws. You have an effective testing method. You have quality control, all of those things. You're in the strongest legal position to defend your decisions to a judge, to a court of law, that sort of thing. So some things you need to consider when looking at the legal defensibility of a drug testing policy. Number one, the laws. The state drug testing laws are different in every state. So often I have employers come to me and say, can you just tell me, what to do that's going to work in all the states? Just give me like a blanket policy or answer for this issue that's going to work everywhere. Unfortunately, that is not possible. The states have very different requirements, and what works well in one state may not work well in another state. So you need to know what states apply to your workforce. There are many employers who operate in different states, or there are employers who are based in one state, but they'll send crews to other states. And you need to know what laws are going to apply to which employees, what laws you need to be following. Not just drug testing laws, but laboratory licensing laws need to be considered. Marijuana laws are not always grouped in the state drug testing law section, but those very much impact workplace drug testing. Federal laws, hopefully any employer who's federally regulated knows that, but what employees are federally regulated and what employees are not, and what kind of drug testing policy you need for those different employees. You need to know when to conduct drug testing, who to subject to drug testing when coming up with a policy, and then how to conduct it. Are you going to do lab-based testing? Are you going to do instant on-site point of collection testing? Are you going to use urine, oral fluid, hair? Those are all factors that need to be considered, and not just slap together a policy that you think is going to work for all people at all times in all states. That is just not possible. So I'm going to walk you through some of the state drug testing laws that apply to the workplace, so that you know what issues you're facing. The first, when we talk about drug testing laws, states that have state drug testing laws, which most do, have either a mandatory law or a voluntary law. A mandatory law is just what it sounds like. All employers are subject to that law. Any employer who's going to do any kind of drug testing has to follow the mandatory law. Voluntary laws, don't we wish all laws were voluntary, right? We say voluntary law in the industry to talk about drug testing laws where not all employers are required to comply with those requirements, but those who do comply receive benefits. So most often, employers who follow the voluntary law are able to receive a 5% discount on their workers' compensation insurance premiums. So an employer who, for whatever reason, doesn't want to receive the premium discount, maybe they are self-insured, maybe the benefits, the costs that they can save by doing a different kind of drug testing are going to outweigh the 5% discount that they would receive, or various other reasons, an employer would say, I'm not going to comply with the voluntary law and I'm not going to receive those benefits. And they're perfectly free to do that. They do not have to comply with the law. Other employers who do want to receive the insurance discount or the premium discount or other incentives, some states permit a protection from certain kinds of lawsuits, things like that. You say, I do want those incentives, you follow the voluntary program and you receive those benefits for complying. There are also state industry-specific laws. For instance, the transportation industry or the construction industry will also often have laws that apply only to that industry. Sometimes bus drivers have certain requirements that they must follow, like city bus drivers, school bus drivers. Child care industries sometimes are regulated. Industries like mining or nuclear workforce or offshore workers have certain laws that apply only to them. And compliance with those laws is mandatory for any employer who works in that industry. As well, unemployment compensation denial laws and workers' compensation denial laws will have specific requirements. These operate more like voluntary laws, where if an employer does not comply with the requirements of the unemployment compensation law, what it means is they can't deny unemployment comp when they discharge an employee for testing positive. So they don't get in any legal trouble, they're just missing out on a benefit. And the same with workers' comp denial. If an employer wants to deny workers' compensation benefits to an employee who tested positive for a drug, after an accident, they have to comply with the requirements of the workers' comp law. And not every state has an extensive list of requirements for denying unemployment comp or workers' comp, but you do need to check because some have different requirements and they're all state-based. And of course, the marijuana laws. Nowadays, most marijuana laws do have specific details about workplace drug testing. Well, maybe most is an exaggeration, but a lot do. A lot have specific requirements for the workplace, and so you need to know. And you can have different requirements for recreational cannabis and medical cannabis. You might have to treat medical cannabis users differently than how you treat recreational cannabis users. So it's important to look at both of the laws in every state. We also have case law. Now, case law is a legal decision issued by a court, and it's written down and it is binding. So for example, an employee gets fired for testing positive for marijuana and they sue their employer and they say, I'm a medical user, you can't discriminate against me and fire me for testing positive for medical cannabis. The case goes through the courts and it goes through the appellate courts, and the appellate courts interpret the state's marijuana law or disability law and come to a decision, and they write and publish that decision. Then that becomes law, and all employers in the state are going to be bound by that decision of that court. So occasionally there is important case law that employers need to know applies to them. And of course, there's federal regulation. So this only applies to federally regulated employers, which is usually the Department of Transportation or federal government employees. Now, if an employer is regulated by the federal government, by the Department of Transportation, for example, they do not have to comply with the state's laws. If the state's workplace drug testing laws are different than the federal regulations, the employer is going to follow the federal regulations and not the state laws. If you are a regulated employer, you must comply with those laws, and they're very specific and they're very strict. Some state laws mirror the federal regulations. Or for example, Puerto Rico says, oh, you have to test if you're going to, any employer in Puerto Rico, I was going to say in the state, not in the state, not in the country, any employer in Puerto Rico is required to comply with Puerto Rico's laws about workplace drug testing. And Puerto Rico's laws say we follow SAMHSA's guidelines. So an employer in Puerto Rico, even if they're not federally regulated, is going to need to know what SAMHSA's regulations are, because the state is requiring them to follow the same guidelines. So like I said, federal regulations are always going to trump state laws. If an employer is federally regulated, he or she will just follow those regulations and not worry about the state laws. State laws are going to trump city ordinances if they're in conflict. And what that means is there can be a city ordinance that can be followed in addition to the state laws, in which case you follow both. You would only ignore a city ordinance and only follow a state law if you can't follow them both at the same time. If a state law says you have to test for marijuana and a city ordinance says you're not allowed to test for marijuana, you can't do both of those at the same time. If a state law is silent about marijuana, doesn't talk about the workplace in their marijuana law, but the city law says you are not allowed to test for marijuana, then you can comply with both, because the state law is not truly in conflict with the city law. But if there is a conflict, state law trumps city ordinances. If it's confusing, which it often is, even for lawyers, the best bet is to follow the narrowest definition, be the most conservative in your testing to stay safe. And, we went through all these different laws. You need to be sure that you're compliant with the state laws, with the mandatory laws, or if you're following the voluntary program, with the industry specific laws, all of that sort of thing. So multi-state employers need to have a policy that has separate sections for the different states in which they operate. You cannot have a blanket policy that's going to work in all states. What we do at Kern Consulting Group, we put together a policy, and then we have an addenda for each state in which they operate that has those state specific laws. So for Ohio employees, you have the main policy, and then you also have your Ohio addenda. And then New York employees have their New York addendum, Florida employees, that sort of thing, so that you do have a main policy that applies to everyone, and you do incorporate the state specific laws for the employees in that state. All right, so we're going to talk about different drug testing methods and how this affects legal defensibility. There are many drug testing methods to choose from these days. There was a time when it was all urine testing, and that was all that anyone thought about. And now there are so many options out there that employers just really need to educate themselves on the benefits and disadvantages to all the different types of testing. We have urine testing, of course, but we have lab-based urine testing, and we have point of collection urine testing. Now, point of collection urine testing, I mentioned earlier, would be an on-site result, an instant result, where the employee or applicant is giving their sample and you are getting an immediate result as to whether they're positive or negative. That is point of collection testing, and that can be very restricted in certain states. So you do need to be very clear about where that's allowed and where that's not. Lab-based urine testing is where they give a sample and the sample gets sent to the lab, and then the lab later will give the result of positive or negative. You have hair testing, of course. You have oral fluid, which I've been talking about a lot. If you're not familiar with oral fluid, it's from your mouth. It's saliva testing, basically. And like urine testing, you can have an instant result, a point of collection test result for oral fluid, or you can have a lab-based where you collect the saliva and send it to the lab and get a result that way. Breath testing for alcohol has been around for a long time. Breath testing for drugs is being developed now. And I think it just remains to be seen what's going to come of that. It has not been well established yet, and we just need to see where the science goes with that. But I'm sure that different drug testing methods are going to just continue to be developed and quickly because there's such a need. I have heard of sweat testing that's being developed as well. So there's a lot out there for employers to consider. But with all these different methods out there, the federal government has endorsed 2 drug testing methods. And when I say endorsed, it means federal law permits testing using lab-based urine and lab-based oral fluid. Lab-based urine is what has been around for ever and ever and ever, right? It's still the #1 testing method because it's the one everyone thinks of. It's just historically been the go-to. But the federal government now permits lab-based oral fluid testing. And that's a big deal because the federal government does not move quickly, shall we say. They take a lot of time to make changes to their programs. And they put a lot of time and money into investigating changes to federal law. And so this was a long time in development. And as of May 2023, the federal government allowed for the Department of Transportation testing, lab-based oral fluid testing. Now, really quickly, I'm just going to talk about one of the benefits to lab-based oral fluid testing as compared to urine testing. I mentioned earlier that urine testing detects metabolites, whereas oral fluid testing, at least for marijuana, detects the parent drug. And that goes hand in hand with the fact that lab-based oral fluid testing is a recent use detection method. When a person ingests a drug, it metabolizes in their body and certain components of that drug get secreted into the urine. And urine-based drug testing is looking for those certain components that get metabolized by the body and then secreted into the urine. Oral fluid testing does not work that way. Oral fluid testing is a very close to immediate result. And what I mean is when someone ingests a drug, it is almost immediately showing up in their saliva. And so whereas you can, say, smoke marijuana and take a drug test 20 minutes later and show up marijuana negative because it has not metabolized through your body yet, oral fluid is going to most likely detect that marijuana because it's catching recent use. As far as marijuana goes as well, oral fluid, the marijuana is leaving the oral fluid more quickly than the urine because of the metabolizing process and all that. I'm not a scientist, but this is just my understanding of the science behind it. We all know that marijuana is showing up in a person's urine much longer than other drugs, and it shows up in a person's urine much longer than it is showing up in oral fluid. That can be good or bad depending on what an employer is looking for. If you're looking for historical use, what's this person's lifestyle? Does this person use drugs over the weekend or regularly? You probably do want to use urine because it's going to be capturing use from a long time ago or a lot more use. If you want to know, did this person use drugs today while they were working or, very close to their work time, oral fluid is much closer to giving you that information than urine is, particularly with marijuana because of the way the body metabolizes it. Hair testing is legal in most states. It is currently not permitted by the Department of Transportation, but the Department of Transportation is investigating hair testing, investigating adding hair testing to the permissible samples by Department of Transportation. Hair testing is something that's going to detect very historical use, even, well, depending on the person's hair. If you have, long hair like I do, you've got, if a person with long hair has used drugs for a long time back, you're going to be able to detect a lot of different drug uses in that hair sample, especially compared to oral fluid testing. So hair testing is not a recent use detection method. It is a historical use detection method. So again, it depends on what an employer is looking for and the laws of their state. When we're looking at state marijuana laws that have protections for employees and say that an employer cannot discipline an employee for off-duty marijuana use, historical use detection is not going to help you very much with that law. You get a positive hair test, you're going to have no way of knowing just based on that hair test if the person was using drugs on duty or off duty. If they were impaired while they were on duty, it's not going to give you any of that information. So that is one situation where you do need to look at the laws. Not only like hair testing might be permitted in a certain state, but if the state does not allow you to discipline someone for marijuana use that was off duty, if the person wasn't impaired, you know, that hair test positive for marijuana is not going to be very useful. So if a drug test result is challenged, you know, an employer really wants to think through, what if this policy was challenged? What if my drug testing method, you know, if I got sued and I was in a court having to defend my choices? Making a choice based on what is legal under federal law can really benefit an employer. If you have to come to court and say, I chose lab-based oral fluid testing or lab-based urine testing because I know how strict the Department of Transportation is, and this is how they do their testing. And so I wanted to do best practices. And in my opinion, what the Department of Transportation does is best practices. That's a really strong defense for an employer compared to, and I'm not saying not to try new methods or not to investigate new methods, because, you know, we're going to get some great stuff coming out of research now. But if you're coming to court and you're defending your practice, something that is longstanding, something that is very well regarded as best practices, is going to be a very strong defense for how that drug testing is conducted. So let's talk about the 3 C's of legal defensibility. Number 1 is compliance. And it's number 1 for a reason, because it's the most important thing. If you are not following the state or local laws, your policy is not going to be legal defensible, period. We can just shut it down right there. It is the most important thing an employer can do to make sure that their policy adheres to the state and local laws. All right. And that's the marijuana laws. That's the mandatory state drug testing laws. That's the industry specific laws. That's the laboratory licensing laws. I didn't talk very much about laboratory licensing laws, but those come into play if an employer wants to do rapid on-site testing. If you want to collect, if you want to collect oral fluid and test it right there on site, you need to make sure that the state's laboratory licensing laws don't require that be done by a laboratory. There are a few states where that is a problem. So you need to make sure if you're testing on site that you're in compliance with the state's laboratory licensing laws, and that you are compliant with all the states in which you operate. Again, I know I've mentioned this, but I have just heard this question and this issue so many times from employers. You don't get to pick one state law and just follow that one. If you are based in Florida and you have employees all over the country, an employer cannot say, we're based in Florida, so we apply Florida law to all of our employees across the country. You can't do that. If you have employees in New York and you're based in Florida, the employees who are based in New York need to be tested in compliance with New York's laws. If you have a crew in Nevada and you are drug testing them while they're in Nevada, you need to comply with Nevada's laws while you're testing them and while they're working in Nevada. So every single state needs to be covered by your policy. No two states are alike. You've got to do the research. And if the employer, him or herself, does not want to do the research or does not know how to do that, reach out to us at Current Compliance, reach out to DrugPack. We can all help you put together a compliant policy. All right, I know that it sounds complicated, but it doesn't have to be. There are professionals who do this full time and who know how to do this, like that. So the policy has to be compliant. So number 2 is the policy needs to be comprehensive. It needs to cover everything. It needs to cover who is going to be tested, when are they going to be tested, how are they going to be tested, how are samples going to be collected, what kind of sample is going to be collected. And then if there's a violation, number 1, what qualifies as a violation? Does a refusal to take a test qualify as a violation of your drug testing policy? Is that addressed? If you don't have that in your policy, are you going to be able to discipline or discharge an employee who refuses to take a test? Things like that. And then what are the consequences for a policy violation? Do you have second chance agreements? Or are they immediately fired, or do they go through a disciplinary process? Again, look at state laws, because there are a few state laws that have very specific requirements on these consequences. There are state laws that say people need a second chance agreement. They need the chance to go to rehab, get clean, and come back to the workplace clean before they're fired. So look into that. And yeah, what employees are subject to testing? Is it all employees? Is it management, or is it only safety sensitive employees? Is it only certain departments that are going to be tested? Put that all in a policy. And really, more is better when it comes to written policy. My personal opinion is, when it comes to marijuana in particular, more is better. Is medical marijuana permitted? Is recreational marijuana permitted? Is CBD permitted? Because depending on a CBD product that someone is using, someone could be using what they believe to be CBD and not marijuana and end up positive on a drug test because their CBD contains THC. That's a whole other area, but cover CBD as well. Medical marijuana, recreational marijuana. If the law changes in a state in which you operate, like Ohio just legalized recreational marijuana, either update your policy or make it clear to your employees that your policy regarding marijuana is going to remain the same, because they're not going to know. Your employees are not going to know unless you tell them, listen, I know recreational marijuana just got legalized. Employees are still not permitted to use marijuana, and if you test positive, you will be discharged. That sort of thing. That kind of comprehensiveness is only going to help. And the third C, we have compliance, comprehensiveness, and consistency. You can have the best written policy in the world, but if it is not being implemented consistently, it's gonna be a problem. You've got to follow the policy. You've got to follow it every time. Don't make exceptions for certain employees. Treat everyone the same under the policy. Conduct your drug testing the same every time. Don't offer second chance agreements only to certain employers or certain employees and not to others. Not to say any of this is illegal. It's just that's the sort of thing that brings about a lawsuit. It doesn't mean that an employer is going to lose that lawsuit, but it's just best practices to be consistent, to treat all the employees the same under the policy, and not to play favorites and not to change your policy up in the middle. I've had employers call me and say, this is what I had one time. An employer said, this person tested positive for this substance, and then it turns out they had a prescription and they showed us the prescription, but now I want to fire him anyway. Like, that is such trouble. That is going to get you in a lot of trouble. You've got to follow your policy. It was like, your policy says that if he has a prescription, it's okay. Yeah, that's what our policy says. Then you got to follow your policy. You're going to get yourself in hot water otherwise. If your state law allows exceptions, if not everyone has to be tested, make that clear in your policy. Write it out in the policy and don't leave it up to game day decision as to how you're going to apply this. Be consistent. All right, let's talk some more about legal marijuana. I know I keep saying, I hear this and I hear this. Okay, this is the biggest thing that I hear. This really is the biggest thing that I hear all the time now. Should we just drop marijuana testing completely? Is it even worth it to test for marijuana? Because it is complicated and it is changing all the time, and there are conditions in many states, a lot of hoops you have to jump through when you're testing for marijuana. So do we even bother? Coming from the lawyer, you absolutely should be testing for marijuana. Marijuana testing is legal in every single state, the exception being New York. New York is very complicated. New York, for the most part, you cannot test for marijuana, but there are some exceptions even in New York. But outside of New York, everywhere else, you can test for marijuana. The question is, what do you do with the results in certain states? Like we're talking about in California, if you have a urine test and it detected non-psychoactive metabolites, what do you do now with the results? So that is where it gets complicated, but do not drop testing, all right? Lab-based urine testing has been around for 30 plus years. Lab-based oral fluid testing is very well regarded now, so well regarded that the federal government, has approved it. Oral fluid testing is a recent use detection method. You combine, I'm sorry, I thought maybe I have one more slide, but let me talk to you, about marijuana impairment, because we do not currently have a drug testing method that can tell you an employee is impaired or is not impaired. We do have a drug testing method that says this person used marijuana recently, not 3 days ago, not over the weekend, recently. You combine a recent use detection test with signs of impairment in the workplace, and that is a legally defensible way to discipline or discharge an employee in all states. There are no states that prohibit an employer from disciplining, I'm sorry, I'm stumbling over my words at the end of the webinar. There are no state laws that prohibit an employer from disciplining or discharging an employee who is impaired by marijuana on the job. And I'm going back to my second slide, where an employer is legally liable for the actions of his or her employees. With the rise of marijuana legalization has come the rise of marijuana use. No value judgment on whether that's good or bad, but I can say that that is bad for the safety of the workplace. People are using marijuana more than ever, and people are impaired by marijuana more than ever. Whatever a person does on the weekend, you can have your own opinions on that. You do not want to have impaired employees in the workplace. That is not safe. That is not good for anyone. And by failing to test for marijuana and failing to take any action on marijuana use, that workplace is going to be less safe. Just full stop. It's going to be less safe if people are impaired by marijuana in the workplace. So as a lawyer, when I look at the potential liability for having an impaired worker in the workplace, what can happen with that, the kind of safety risk that you're up against, the kind of tragic accident that can happen with an impaired employee, like one accident, just one accident with an impaired employee can shut down a company. And the risk, if we're balancing the risks of being sued for not conducting marijuana testing correctly versus being sued because someone was seriously injured in the workplace because of an impaired employee, that's an easy answer to me. To me, that's an easy answer. It's worth the trouble to marijuana test to prevent tragic accidents like that and that kind of huge liability. And there's a way to do marijuana testing right. There's a way to do it correctly. There's a way to write your policies that are legally defensible, that are compliant, to train supervisors for signs of impairment. Signs of impairment combined with recent use detection of marijuana in a drug test, that's a legally defensible drug testing policy. I'm going to wrap things up now by just saying the 5 things you should do. Know the laws. Know the laws in the states in which you operate. And if you don't know them, research them. If you need help, reach out to Current Consulting Group. We have a whole database related to workplace drug testing in all the states, in Washington, D.C., in Puerto Rico. Number 2, be as comprehensive as you can and keep your policy up to date. Don't write it and then throw it in a drawer and not look at it for a decade, okay? Look at it every year and figure out what's changed and what hasn't. If you can, use a testing method endorsed by the federal government. That's very legally defensible. It's not required in almost any state. There's a few states where that is required. Most states it's not required, but it's very legally defensible. Number 4, use a SAMHSA certified lab or an FDA cleared point of collection testing device. Again, a better way to stand up in court and say, yeah, we chose this method because it's cleared by the FDA, or this is certified by the federal government. So, you know, we had a reason to believe that was going to be the most effective and reliable drug testing we could do. Don't ignore marijuana laws, number 5. That should be obvious by now. And be consistent. Follow your policy, keep up with it, be consistent, and you have a legally defensible drug testing method.
Thank you, Yvette, for a great presentation. On behalf of the Current Consulting Group and Drug Pack, we hope you found today's presentation informative and helpful. I want to thank Yvette Farnsworth-Baker from the Current Consulting Group for speaking on this topic and sharing her expertise. If you submitted a question that we didn't answer here today, we will answer you offline. We will also send you information and a follow-up email on how to access the recorded version of today's presentation. In addition, we will also send you continuing education information for those of you that qualify to receive 1 credit for attending today's presentation in its entirety. Thank you for your attendance today, and this concludes today's webinar. Have a wonderful day.